If you've just been appointed counsel in a criminal matter, it's important to understand the next steps of the process. So typically you'll be appointed counsel either at the arraignment hearing or shortly thereafter. And what that means is that you have qualified for indigent services. So you probably filled out an affidavit of indigency. And the judge has determined that you are in fact indigent. And what indigent means is that you don't have sufficient money to pay for legal counsel on your own, right? Constitutionally, you have the right to an attorney if you can't afford one. So the judge is going to make that determination as to whether or not you can afford one. If the judge determines you don't have the funds to afford an attorney, then you have the right to a free one. And that's when one will get appointed for you. Now, appointed counsel is going to be a little bit different than private counsel. Typically, you're going to be working with a public defender. Most jurisdictions, public defenders are overloaded with cases. So you may not get the hands-on, one-on-one experience that you might otherwise get with private counsel. That doesn't mean that a public defender is not going to be effective. In fact, they're often some of the most effective criminal defense attorneys in the courtroom. Reason being is that they have such a great relationship with the prosecution because they're in the courtroom together day in and day out. So they understand every single nuance. They understand all the individual prosecutors, and they're likely to get you pretty good results. That being said, the communication between you and the public defender may not be that robust. And what I mean by that is you may not hear from your public defender until your next court date. You may not have a number to get in touch with them. They may send you a letter, but you may not hear from them, and you may not be able to get in touch with them until your preliminary hearing date. And don't let that alarm you. That doesn't mean the public defender is not doing their job. It just means that you're not going to get the hand-holding that you might otherwise get if you went with private counsel. That just comes with the territory, and it's to be expected. Now, some jurisdictions may be completely different. I'm just speaking from personal experience in the jurisdictions in East Tennessee. So when you show up to your court date, right, it'll usually be set for a preliminary hearing. At that point, your public defender will be there. Y'all will probably talk for a few minutes. He'll go over the charges. He's probably pulled a background search on you and sort of knows what your past criminal history is. And he may have already done some discovery, and he may have done some digging to determine what kind of evidence the prosecution has against you. Now, at that point, he's going to talk to the prosecution and see if he could come to some sort of agreement with the prosecution. Sometimes that works out, sometimes not. And if it doesn't, they'll move towards what's called a preliminary hearing. I've done another video that discusses a preliminary hearing in more detail, but don't be alarmed. You don't have to get up and speak. Your prosecution their prosecution's going to put on sort of a mini trial where they convince the judge that there is probable cause that you committed the crime. And your side, right, the defense side is going to cross-examine the prosecution's witnesses. Preliminary hearing doesn't always occur, but when it does, that's the gist of that proceeding. Now, after the preliminary hearing, if the judge finds probable cause, he's going to bind it over to a grand jury, at which point you'll either go to criminal court or in some cases, circuit court. Now, that doesn't mean that your window for plea negotiations has shut. You can still negotiate even after the plea, even after the preliminary hearing. And in fact, sometimes that's where cases settle, and sometimes that's where they settle for the best terms. So don't be alarmed if your case goes through a preliminary hearing and is bound over to a grand jury. It doesn't necessarily mean that it's going to go all the way to the full trial. So I hope that gives you a bit of a background as to what to expect if you've been appointed counsel. You may not be able to get in touch with them right away. Doesn't mean they're not working on your case. They're very busy. They're also very good at what they do. So don't be alarmed. Trust in your defender. And if you feel they're not doing a good job, try to open up a line of communication and talk to them. Sometimes they get overloaded. Sometimes things do slip the cracks. But just because you haven't heard from them doesn't mean that they're not working on their end. So I hope that gives you a bit of background. I hope that's helpful. If you are in need of criminal representation, if you have a criminal matter, for any other legal matter for that matter, give us a call at Christian Cities Legal Services, and we would be happy to give you a free consultation and talk with you about your legal situation.